Please be seated. We'll hear argument in case number 240881 in the interest of KN, KL, KL, and KL.
Please the court. Mr. Sharpie will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, opposing counsel. We have a parental termination case in front of the court today. The petitioners, and I'll be speaking for both the mother and the father. Mother was terminated as to 1 child. Father was terminated on 4 children. Mother was left a possessory conservator of the younger 3 children. Kind of a split jury situation on that, the verdict. But I'll be arguing on them both. From the petitioner's perspective, this is a case, using Justice Busby's words, is it a marginal case which justifies the death penalty in a family law case of termination of parental rights? According to Chief Justice Blaylock, is it a case in which the failure to check the boxes for the department resulted in the termination, and is that just? Is that something that should be upheld? The case at its heart deals with not a failure to work services, but a refusal to work services. There was an outcry made by a child. CPS initiated an investigation. They did not remove the children. They initiated an order to work services under the new part of the family code where CPS is supposed to initiate family-based services, not remove the children, but see if they can rectify the situation so that the children are safe in the home. So an order was entered to work services. My client, the mother and the father, said, no, we're not going to do it. CPS, if you're familiar with these cases, usually an order to work services, has a plethora of things that parents are required to do. In this particular case, all that was requested was an anger management class, a psych evaluation, and counseling for both the mother and the child. This has started in March of 2022. There had been a previous case, approximately 1 year before, where similar allegations were made. The allegations were mom had pulled the child's hair. Child said mom was dragging her by the hair, that she was put in timeouts, forced to stand against the wall, according to the child, for days. There were allegations that she was deprived of food, not allowed to eat what the rest of the family ate. Of course, if you read the transcript, mother had an excuse for each one of these things, claimed the child was exaggerating, and really she was using timeouts to control a strong-willed child that had been diagnosed with ADHD. She was taking away her iPad as punishment. The food deprivation allegations where she did not want her eating breakfast because dairy intolerance at school.
Are you saying that there's no evidence in the record to indicate that this child had been endangered?
Yes, that's what I'm saying, Your Honor.
Okay, what would you say is the evidence that would indicate the highest level of endangerment? Or if you don't want to use that word, just, I
understand what you're saying. Yeah. I think what we have here, as the Court of Appeals said, they termed it as discipline that had crossed the line. The question here is, given the constitutional right of a parent as found by the U.S. Supreme Court.
I understand that, but I'm just asking you, what do you contend is the most damaging evidence against your client, basically, with regard to endangerment, with regard to those grounds? I'm not talking about best interest right now.
Yeah, and I understand the question, Justice Lehrman, but I don't, as I sit here and think about what is the most damaging, it's hard for me to say that using timeouts is somehow an endangerment to the child. It's hard for me to say that there was an initial spanking in the earlier case.
Is timeout worse than spanking?
Well, I guess it depends on the child.
Rather get it
I'd rather take the spanking than the timeout.
Start at the top, please.
Yeah, no, I mean, from a personal perspective, I think all of us are of the age that we have been there, where corporal punishment in West Texas at Levelland High was a standard operating procedure.
What about treating that one child differently than the other children?
You know, I understand that, but I'm sure everyone is familiar that has had children or familiar with children. The children are different, so each one gets treated differently based on their personalities. Some children are very compliant, they want to please, they do whatever they're asked. Or
Well,
more.
certainly, I mean, I have two children, and they're different, and they were disciplined differently.
So we treat them differently.
But would you not concede that on this record, it does indicate that this child was treated particularly different?
I would agree.
To an extreme than the other.
She was treated differently than the other children. And that kind of dovetails into the second part of it, Justice, in that's the department's position, is this child was scapegoated, was the word they used, and suffered more punishment, let's say, or more discipline than the other children. Yet those children, for which there was no allegations of abuse, no outcry, nothing, dad was still terminated on those children, and they were removed from mother's care. If department's position is this child was disciplined in an inappropriate manner, and these children were not.
As you mentioned, the jury seems to see all of that, and they had a split result as to mother.
Correct.
Doesn't that suggest that there really is some evidence as to the daughter who was treated differently, the one who was removed from mother?
Well,
Repeatedly bruising a child for years, the dragging by the hair, the food deprivation. Yeah, you said there are excuses for this, but I mean, a jury heard all of that.
that's correct.
And if they're correct, I mean, I take it that maybe there would be a factual insufficiency point, but if it's just a legal sufficiency, how can you say there's no evidence?
Correct.
Just explain that to me.
Right. The department is trying to characterize it as a factual insufficiency point of error, which I would agree is not something that would
Well,
be
you
before the
yourself
court.
said there's no evidence. That's what you said to Justice
That's
Lerner.
correct.
So tell me how there's no evidence.
Well, it's in terms of, is there abuse or neglect of the children? Is there evidence of abuse or neglect? I humbly submit that traditional means of discipline, whether it be timeout, taking away electronics, sending a
But
child.
I don't think that Justice Young is asking about traditional. What I heard him ask you was about this child being singled out and being treated differently in terms of years and years of bruising, et cetera.
Well, and again, I'm not going to concede that there were years and years of bruising. There was one incident that was reported, the mother admitted to it, and she stopped corporal punishment at that point. Is it enough to terminate parental rights, though? Because let's assume we're correct, that one child is being treated differently than the other three in the house. As I said, one child may be strong-willed, may be confrontational, may be defiant. The others may not. Is it really the state's job to interfere with a family in that situation and say, no, you can't treat this child this way. You have to treat all the children the same? I don't see
Jury
how.
also found termination based on ground N, and I didn't see any discussion of the evidence in connection with ground N.
Well, what I put in the brief on that is my understanding is this court typically does not address issues that were not addressed by the appellate court. So if
So
this.
you would say that at least that ground would have to be looked at before?
Well, I think there's two options, in my opinion, anyway, Justice. You can remand it back to the Court of Appeals to address those issues if the other ones are disposed of. Alternatively, in the interest of judicial economy, whether as Justice Lerman and I have argued about before, I believe, O
I
requires.
didn't mention O, but O as well.
Yeah, requires that there be a finding of abuse and neglect before anyone's got to work any services to start with, and our position is there was none.
But N is abandonment, right?
And is abandonment.
And what is the status of, the time spent with the child after, before and after?
Yeah, I guess I would say on N, obviously, once the case started, there was no abandonment because the children still resided with the mother and with the father. The family was intact. After the children were removed by force, by law enforcement, they did not have any contact with the children after that. And it is true they refused to work services. And that was the basis of the department not allowing them to see the child. So I don't know if it's circular, but to say, I didn't do anything wrong, I'm not going to do what you tell me to do.
Mom saw the three younger children, but not the older child?
My recollection, Your Honor, is there was one visit, telephonic. At that point, the counselors terminated any more visitation based on her refusal to work services and cooperate. I would characterize that as punitive. You don't do what I say, so you get punished. Just like the mother, the department says, you go to timeout because you're not doing what you've been told to do. So you don't get to see your children until you comply. If that constitutes voluntary abandonment of the children, I guess it does.
You're saying there's no the record does not include any situation in which the parents had the opportunity to see the children and chose.
I know that the department will argue that if they had wanted to see the children, all they had to do was sign the release, for example, or go to the counselor, or go get the psych eval, and they would have been allowed to see the children. And as the caseworker testified in the record, if they'd have done that, they'd have got the children back. The caseworker testified. If they'd have worked services, it's highly unlikely that the children would not have been returned to them. That's what they wanted. They wanted them to do what they were told. And they didn't do it. There's no way around
The jury
it.
heard lots of evidence about that, including evidence that the department retracted its probable cause or reason to believe finding of emotional abuse in connection with the first case. So the jury had all of that, and yet they came out with the result they did. What's your explanation for that?
Sometimes juries get it wrong. That's all I can say. I mean, I understand they were tried by a jury of their peers. That's what we provide for. Why juries do what they do, people can speculate. I mean, they have TV shows about it and supposedly jury consultants that can tell you. But in my 32 years of experience, I have no idea.
So where is the line between permissible corporal punishment and child abuse? I mean, you're saying as a matter of law here that the evidence of the bruising, the shoulder injury that lasted for a long time, the hair pulling, you're saying as a matter of law that's not enough. So I guess I'm wondering if you can articulate where the line is.
Yeah, I mean, that's what I'm saying. I mean, I don't know if you can provide a bright line test, but as is cited in the brief, opinions by this court and the U.S. Supreme Court talk about the state is not, we have a fundamental constitutional right to raise our children as we see fit.
Well, but surely you would understand that, for example, if a family had decided, a mother and father, that a discipline that they were going to use would be to put a child in a closet and not feed that child for 48 hours, that would probably cross the line. Do you agree with that?
I agree with that.
So there's a line.
There's a line.
It can't just be any discipline that a parent decides. A parent doesn't have a constitutional right to decide that any discipline is okay.
No
and
question.
So where's the line?
That's right. The state's got to balance its interest in protecting children, its citizens, and the parent's constitutional right to raise children as they see fit. Where are we going to draw that line?
What about something like malice?
Well, I would be hesitant to use something like that as a test, because now we're talking about the subjective intent of the parent. We have to read their mind as to whether they're being sadistic, because that's how they are, or is it the old, this is going to hurt you, or it's going to hurt me more than it hurts you, because I don't want to punish you. I love you. I don't want you to be hurt.
But
I'm doing
that does
this for
seem
your
to
own
get
good.
at the true distinction between
I mean, malice would certainly
morally
be it.
blameworthy, conduct and
Yeah,
conduct that some people might view in good faith as legitimate discipline.
in a trial court scenario, we argue all the time about there's the discipline that is administered to correct the child versus discipline that is administered because someone's angry and taking it out on the child. One is definitely crossing the line, one is not. How the court is going to determine, or what language we are going to use to provide guidance to not only the department, but to parents. As we've talked about, I've seen, I don't know if it's opinions or in commentary, that parents should not have to be in fear of raising their children or disciplining their children, because they may get a knock on the door from CPS.
But why isn't that a classic jury question? I mean, if you can't articulate a clear standard, everyone agrees there's a line somewhere.
Yes.
I mean, are we really going to do better than 12 citizens looking at the facts and hearing the witnesses testify and looking at the record and making a judgment call?
I think before we get to the jury trial, we need to have some clarification about when is the state entitled to intervene and when are they not. And we need to have some clarification about, does a parent have the right, shall we say, to tell the state, I don't agree with you, and I'm not going to work your services. That's really what the case is about. I understand there was a jury trial, there were factual allegations that went both back and forth, but nevertheless, from our perspective, the termination here did not result because of the spanking. It did not result because of the alleged food deprivation. It didn't result from the timeouts. It resulted from one reason and one reason only, because they told the department, we are not going to cooperate. I'm not going to say that, I understand, I've said it before, the department has a very, very difficult job, a job I would not want. And I'm not going to impute vindictiveness necessarily to the state agency. But from the outside looking in, that sure looks like what happened. They went in, they did their investigation, they were allowed, over the 3 years that this was going on.
What is the evidence that indicates that that's what they were doing rather than using their best judgment to do what was best for this child?
I don't think there's direct evidence of that. I think we have to imply that from the actions. Actions speak louder than words. And over the course of the 2 or 3 years before the removal, they did not remove these children from the house. In the department's brief, they cast the mother as heinous in physical abuse, food deprivation, all kinds of things.
Well, there's something positive about the department taking even very flawed parents and saying, I think that we can still work with you on this. We think we can solve this. But in order to take this heinous behavior and get it to a part where we don't have to destroy the family, here are some things that have to be done. And so for a parent that is doing terrible things and then refuses to do that, I don't see how that makes the department blameworthy so much as maybe underscore that the parents actually don't have even enough love for their children to do some relatively simple things so they can see their children. Not to do a psychology exam at the price of not seeing my child?
I understand. I think for a lot of us that are put in that position, we would say, okay, I'll do whatever you say. I'll do whatever you say. Just don't take my children away, right? Is that a rational position to take?
Maybe not whatever you say even, but within some limits, if there really were problems with the family and the state comes in and says, look, there's some serious problems here.
And I think the legislature has put that forward with the new family-based services, saying you have to try to work services first before you remove those children. We're not just going to have an automatic removal because there's an outcry.
But now you're kind of talking out of both sides.
I know.
Because you're
I understand.
But it's a tightrope for the department here.
Yeah, it's a difficult position, and that, assuming the benefit of the doubt, that's what they initially tried to do. But now we're talking about an emergency removal of the children. That's where it culminates. That's where the whole thing goes off the rails.
If a parent was ordered, based upon the recommendation of the department, to go through some counseling based upon disparate treatment of the children, in line with this case, where one child has been scapegoated, and that can cause some emotional scarring, serious emotional scarring to that child, and the parent says, nope, you tell me, I'm not going to do it. Wouldn't that be some evidence of that parent's lack of introspection as to whether those acts could be harmful to her child?
Certainly, but we're dealing with termination under D&E, which requires endangerment, requires a course of conduct.
Are you saying emotional damage couldn't be endangerment?
Well, keep in mind, the department ruled out emotional damage. They said, the department itself said, there was no emotional abuse here.
Was that the first engagement with the department?
That's correct.
Not the second?
I don't believe that was from the second.
No ruling out in the second.
I don't think the administrative ruling came out until the first one was actually done, and then we started the second one. Keep in mind, if you want to talk about that evidence, both the grandmother and the aunt who testified about the oldest child's mistreatment had no concerns about the younger children at all, and we're not concerned about physical abuse. We're only concerned about the disparate treatment.
Let's assume that we agree with you on that. We're really focused on this one child.
Okay. Well,
I mean, I'm not saying I know what we're going to do, but I'm saying just a lot of
No,
the questions,
I
if that were
understand,
to
I
happen.
understand. And the point, if I understand you correctly, Justice, is does not the fact that they refuse to work services indicate a lack of interest in the children?
Or introspection.
Or
even.
introspection, that's true. And the question, I guess, for the court in weighing the constitutional rights of the party, maybe she's not the best parent. Maybe she didn't make the best decision. Maybe she lacked introspection in looking at this and saying, you know what, the easiest thing to do is get this out of the way and then go to Louisiana and put it all behind us, right? She didn't do that. But the statutes and the balancing of the constitutional rights, I think, we can't get into the fact that the parent lacked the appropriate introspection or the appropriate intelligence, or however you want to, or weighing the risks, didn't weigh these risks properly. I think in hindsight, they regret their decisions, obviously.
We
In
have to
hindsight.
see whether or not there are the predicate grounds. Seems like there's at least some evidence as to the one child for mother, and then you move to best interest. And the jury, at a heightened standard, I mean, it's not just a civil preponderance standard, divided that. Now, on appeal also, we have a heightened standard for this. So I'm wondering if the best interest is the place where, if you have any argument as to mother, and I hope you'll also briefly address any distinction about father. We're way past time, but we need to hear why he's different.
Well,
Is best interest the place where maybe some of that work can be done?
I understand, and best interest, in my opinion, my experience, is a completely factual type of determination to be made.
You don't submit to us that there's any distinct appellate role for us to play? Like, once there's a factual determination, that's just... it is
Well,
what it is.
obviously, you can raise factual insufficiency at the appellate court, which we did, and they declined to rule on that. So we have chose, in presenting the petition for review in this case, to focus on the legal sufficiency, because we know factual sufficiency is not going to go anywhere. But since we're talking about it, the oldest child, had been put in the grandmother's care in the first case and chose to come home. There's evidence in the record that after the initial emergency removal from Louisiana, that she missed her parents and wanted to go back to her parents. We won't even talk about the other three that cried themselves to sleep at night because they missed their parents. I think that shows something about best interest. The desires of the child is certainly a factor in that.
Well, I was getting more at just like the legal process that appellate courts would go through here, but briefly, can you say what's distinct about father?
Well, what's distinct about the father is he was not even part of the case until the removal. There were no outcries made against the father. There were no allegations against the father. The only basis that the department can point to for the father is he allowed mother to engage in the disparate treatment, if you will. There was evidence in the record that, if anything, father was the balancing factor. He was the one that said, that's enough, she can have her iPad back. That's enough, she's been in timeout long enough, she can go outside. I don't see any evidence, any allegation of abuse or neglect by the father that justified his termination on all four children. Supposedly the perpetrator was only terminated on one. There are no allegations against dad, and he's terminated on all four.
Well, he never had rights to the first one, right?
He did not. That was a stepchild. And of course, there's a undercurrent that's why we have the disparate treatment.
Any further questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Scanlon will present argument for the respondent.
May it please the court. Sometimes juries get it wrong. This jury did not get it wrong. It upheld termination for both parents on 4 separate grounds, D, E, O, and N. And when my friend came up here, he admitted to you that the parents outright refused to perform any services. That is a court order.
So if you agree that sometimes juries get it wrong, how do we decide, and does the clear and convincing evidence standard affect the appellate review, or are those just 3 or 4 words on a jury charge and then you forget about it?
Certainly not. This court incorporates the clear and convincing evidence by saying, does the evidence offer a reasonable jury the opportunity to form a firm conviction or belief that the allegations are true. And the evidence that was presented to this jury, and what I understand my friend on the other side to be saying in their brief, is really a credibility determination. Did the oldest child get a tug on the hair, or was she drugged on the floor?
My question would be, what determination would we need to make to say that, for us to have the ability to disregard the jury's verdict?
It would have to be an instance where there is legally insufficient evidence. You would have to say there's no evidence that any of the conduct meets the statutory framework that was presented to the jury.
No clear and convincing evidence.
I don't know that that's the standard.
Well, if that's not the standard for appellate review, then the heightened evidentiary standard has no effect.
If the court looks at the evidence and says a reasonable juror could not form a firm conviction or belief that the allegation is true, then that would be
Isn't
the
that
case.
just a rephrasing of, was there any clear and convincing evidence?
Perhaps, Mr. Chief Justice.
It's not the same thing as a normal civil appellate review. I think you're agreeing with that at least, aren't you?
Yes.
If this were a slip and fall case and we ask if there's a no evidence challenge, what we mean by no evidence might be different than what we mean by no evidence in this case because of that heightened standard review, both for the fact finder and on appeal.
Sure, Justice Young.
I mean, the way I look at it is, the question is, was there a scintilla of clear and convincing evidence?
I think that's probably correct. So
Does the department take the position that a refusal to engage in services can be a proxy for conduct leading to termination?
I think we don't have the subsection O grounds anymore from the legislature.
Right, but you seem to say, the parents refused to engage in talking about the findings.
I think you have to have something more probably in the department here.
Because that would not necessarily be conduct directed at the child.
I suppose that's correct. I think what subsection O used to say was you had to...
I'm not talking about subsection O, but it seemed to be like in connection with abandonment and endangerment, the department says, look, she refused to cooperate and seemed to use that as evidence. And is that evidence is what I'm trying to...
I don't know that it's evidence by itself to allow a juror to form a firm conviction or belief.
And what was seeing the children, was that contingent on engaging in services or?
That only happened in March of 2023 before the trial. The removal happened in November. So from November to March, caseworkers, were beating down the door to try to get these parents to perform services. They gave them months to do anything. And
Did the parents make any requests to see the children?
So once there was a lead up to trial, there was a mediation about if you can pass the drug screen, you can have a visitation. And of course, these parents, fled to Louisiana, never made any attempt to come visit their children in person the entire time that the children were in Texas, which I think is also evidence supporting the end grounds, which is constructive abandonment. And as Justice Young alluded to, you don't want to perform a psych eval to be able to see your children again. The jury was...
But in what sense is that voluntary abandonment if the consequence of not being able to see the kids is being imposed by the department?
Well, it was imposed by the trial court, but that was only after a course of conduct where they were voluntarily choosing not to see their children. The CASA worker...
I thought the conduct was, we're not going to work the services, not, we don't want to see the kids.
That's part of it. But the jury was presented evidence that, they went to Louisiana. They stayed there the entire time that their children were in Texas. So that's a voluntary choice. They made the choice to leave the state only when they were presented with further investigation by the department.
What did they try to do to see their children during that period of time when they were in Louisiana?
They would have text messages with the caseworkers. They, I think, had telephonic visitation shortly before the trial. And I think they had maybe one instance where there was a video conference to allow the parents to visit with the children.
Was there a period of time when they were not physically visiting with the children before the court was imposing that on them?
Yes, Justice Lerman. So from the time that they were removed in November until March, when the court ordered, we can't do visitations unless you're going to start to work services. And just a comment on that, the department will do that if there is a concern about substance abuse. They don't want intoxicated parents having visitation with the children.
Is that still, in light of the legislatures having repealed subsection O, I just don't recall, is there any longer for future cases that are going to arise the possibility that the government, and we're judges, but we're the government too, can say, if you don't work these services, then you can't see your kids anymore, and then we'll say that you abandon your kids under N?
I don't know that that's a realistic prospect. I think if assuming we're still under the O grounds.
Oh, for this case, I understand. I just don't recall whether that change, whether the repeal of subsection O or paragraph O avoids this situation happening again.
Sure. I don't know if there would be a basis without O to say you haven't performed services, so we can't give you visitation. But certainly, if the parents are doing things to violate court orders, choosing to move to another state while the department has custody of them, those are grounds for abandonment if they don't make the efforts to try to visit with the children.
If I could ask one other question about the product of the 89th legislature and now of the people of Texas. Last week there was a helpful amicus brief filed by, I think, the Family Freedom Project, where they argue that this should be a strict scrutiny, like constitutional analysis of what limits exist here for DFPS. And I'm just wondering, does this new provision that'll be added to our Bill of Rights, I think as of this week it's been canvassed and is now part of our Constitution, presumably it'll be Article 1, Section 37, does that govern what we do in this case in looking at the constitutional question?
Justice Sullivan, I don't know that it changes much. I think that the court has said in so many words, strict scrutiny has applied since at least 1987 when it issued the Boyd case. And there was narrow tailoring here. The mother had to get a psych eval because she has tremendous anger problems, evidenced by her outburst at Walmart at the school official that filed the DFPS report only because her child had approached her with that information. So, having to perform a psych eval, having to do anger management, those kinds of things are narrow tailoring. And the department does its best to make sure that
Are you agreeing that the strict scrutiny analysis should apply to parental termination cases?
I don't know that strict scrutiny is the right way. I mean, I think that the court has said they have to be strictly scrutinized. That's in the Boyd case and other cases. But if you're looking at a constitutional strict scrutiny analysis, usually you're looking at invalidating some statutory provision. I don't know that it makes sense to apply that to every action that the department has to take to ensure the welfare of the children.
The reason that I'm asking about it, and if you don't have the text of this new provision in front of you, that's fine, but the whole kind of tiers of scrutiny thing that we've taken, I guess kind of borrowed from our federal counterpart, from the early part of the last century. We do tiers of scrutiny, and maybe it's strict, and maybe it's intermediate, or maybe it's rational basis, or maybe it's rational basis with teeth. But now, instead of us putting it into an opinion, we have this text that'll be Section 37. Do the tiers of scrutiny make sense anymore now that it's been codified by the people of Texas in our charter?
I'm not sure, Justice Sullivan. I'd have to maybe think about that. And again, I'm not familiar with the provision. I'd be happy to provide supplemental briefing on that question if that's appropriate.
Well, our court has long
helpful.
recognized a constitutional dimension to these termination cases.
Yeah, I don't see.
And although we didn't find a place in the Constitution to hang it, a hook, now we have one. But we've always recognized that there's a constitutional dimension to these cases.
Absolutely, Justice Bland, and the department's well aware of that. And seeks to protect that right, when it's possible.
So your position here would be that a reasonable jury could have found that this aggressive discipline crossed the line from discipline into abuse?
Respectfully, Mr. Chief Justice, I don't think it's traditional discipline to drag a child by their hair. I don't think it's traditional discipline
My question is it your position that a reasonable jury could have found that this aggressive discipline crossed the line from discipline into abuse?
Yes.
Could a reasonable juror have concluded that this aggressive discipline did not cross the line from discipline into abuse?
No, Mr. Chief Justice.
So no reasonable person looking at this could have concluded that, yes, it's aggressive, it's severe, but it's not child abuse.
No, because it's not reasonable to drag a child by the hair on the ground.
Can I ask about, if you were finished, Mr. Chief Justice, I wanted to ask about the father specifically, if you could help me think through that, Mr. Scanlon. I guess I'm wondering, your best sort of elevator pitch. As I look at the record, he got terminated because he did not intervene to stop the abuse by his wife of her child from a prior relationship who wasn't his child. And then also, I guess it was the methamphetamine possession, which did not involve the kids at all. What's your best elevator pitch for why that's sufficient?
So at the time that the father was arrested for going on a high-speed police chase on a motorcycle, crashing his bike, and being found with possession of meth in his pocket, they did have a 1-year-old infant at home that was only a few weeks old. So I think, to me, that's one of the most convincing pieces of evidence that the jury was presented with, to say
Did the
that...
father appeal timely to our court?
As far as I can tell, yes, Your Honor. He was he appealed to the appeals court and was a separate petitioner for this case. I want to talk briefly about timely. My friend on the other side didn't mention the UCCJEA.
I want to keep you on the question I asked previously. So I understand your position that you're saying no reasonable juror could have sided with the parents here, which is a sort of an aggressive take on these facts, in my view, but if that's your position, I understand. Let's say we disagree with you on that, and we think reasonable minds could differ as to whether this crossed the line from discipline, aggressive discipline, of course, but discipline into abuse. What result then?
I suppose if this court were to say that a reasonable juror could not find that the child was physically abused.
No. Reasonable jurors could have gone either way as to whether this crossed the line from discipline into abuse. Then what result?
If that's the case, perhaps there is not clear and convincing evidence, but I would caution also that this court has at length said jurors have to be the sole judge of credibility. So if the evidence is such that there are conflicting versions of the story that happened, they have to defer to the jury. The court has said
Would you agree that if reasonable minds can differ about whether discipline crosses the line into abuse, that it's got to be within the constitutional right of a parent to decide how to raise their own child in terms of whether they administer discipline, about which reasonable minds could differ?
If the jury is there to apply the community's standards as to whether that physical abuse has occurred, I think that is, those are circumstances where the jury has to be deferred.
What if a jury in Austin thinks that spanking with a belt is child abuse, and a jury in Nacogdoches thinks the facts of this case are just fine? Is that okay? Is that how we're going to do this? I mean,
would be possible that the court, I mean, has to take a look at what kinds of forms of physical abuse actually constitute legally sufficient evidence to find abuse. But
So, earlier Justice Hawkins asked the good question about, maybe this is the kind of thing that, 12 citizens, good and true, decide. But now all the people of Texas, not just 12 of them in Nacogdoches and 12 of them in Austin, but all of them have decided to codify this into our Bill of Rights, which also says that everything in this Bill of Rights is accepted out of the general powers of government and shall forever remain inviolate. So why, I guess I'm rambling, so sorry.
no, that's all right, Justice Sullivan. I also want to just note that looking at, one piece of evidence in isolation maybe doesn't capture the whole picture.
Let me ask you, there's been a lot of talk about discipline, but there was also a lot in this record about this differential treatment with this child. And so what do you have to say about that? I mean, it seems to me from looking at this that it wasn't all just a matter of discipline. It was a matter of this child being treated differently than other children. So what is your comment on that?
There was some evidence that the other children had suffered some neglect, being kept out of school, having their medical and dental care
My question is
denied.
about this child that was treated differently. And what is your comment about whether or not that aspect of it, I'm not saying it was discipline necessarily, just being treated differently, and whether that rose to the level that would constitute abuse or neglect?
It did rise to the level of emotional abuse as determined by the department and CASA workers. There was, to kind of elaborate on that, there was testimony that she was scapegoated. Mother would try to get the second oldest child to be a spy for her, to kind of pit them against each other. And certainly in those kinds of cases, that can constitute emotional abuse.
If community standard, you mentioned community standards, if community standards were to change such that all spanking is considered child abuse by most jurors, is there no longer, does the constitutional right of a parent to decide how to raise their children kick in at some point and protect a parent's right to discipline their child? Or is it just all evolving community standards?
If the department has, determined that there's endangerment to the child, there's maybe a different view on whether physical abuse is actually just a traditional form of discipline. And the department takes the position that, this is actually causing abuse to the child. You, parent, may say that that's traditional discipline, but not every form.
Would you say that there's a constitutional right to administer, reasonable discipline to your child?
I think once we get into what is reasonable discipline to a child, the jury is in the best position to.
So you're saying that if community standards evolve such that most people consider spanking to be child abuse, then we're just going to leave it to juries and there's no constitutional right for parents to administer that kind of discipline?
Well, I just want to say a word on spanking. I mean, we're talking
There are
about.
plenty of people who think it's abusive today. There might be more in 50 years.
And if you're the kind of parent that is, giving the light tap on the bottom and that's explained to a jury, it's hard for me to see how 12 people on a jury are going to say, okay, terminate their rights. But when you have hitting a child so hard that their arm hurts the next day and they have to go to the school nurse, or you have over 8 marks with a belt, the department has a responsibility. It's parents' patriae responsibility to step in and ensure the welfare.
What do you think
of
people
the
in
child.
1876 would have thought of the spanks with a belt, leaving marks, bruises on the arm from having to be grabbed hard? I mean,
There was no Department of Family Protective Services in 1876,
Right.
so they probably wouldn't have had that scenario in front of them.
should we be asking, or might we be interested in what people in 1876 would have thought was within the inherent right of parents under the Constitution to control their children? Or
No,
is, that,
Your
is, that,
Honor.
is that just irrelevant? It
Not
just
for
community
this
standards
case.
all the way down, and we just go with the flow. And
Not for this case, Your Honor. There's been no allegation that a constitutional right has been explicitly violated here.
It's been terminated.
Yes, Your Honor. Under a very highly technical and detailed statutory scheme with the Family Code that the jury was sufficiently advised on.
Chief Justice Blacklock mentioned 1876 standards, and then you had helpfully offered, and I think that the chief agreed, that supplemental briefing. And I wonder whether 2025 standards among the people of Texas, in light of this new Article 1, Section 37, the supplemental briefing would be helpful on that, and then on whether that would play into our analysis here in some way.
Certainly, Justice Sullivan.
I also have a question. There's been some questioning about the elimination of O and what effect that has on the policies of the department. So what happened is now then O is not a ground for termination. But does that have any bearing on the department's responsibility to order certain services for the child? It seems to me that those are two completely different things. It's certainly one thing to say that the court cannot terminate parental rights based upon failure to do these services. You can't terminate. But that doesn't have anything to do with whether or not the department can order, say, you've been taking meth, you need to go to some drug rehabilitation classes. You see what I'm saying? It seems to me that these are two different things.
I agree, Justice Lerman. I think the elimination of O just means that can't be the only grounds for termination. You only really got to O in the first place if there was some other conduct necessitating removal and in order to perform services. And those statutes that allow the department to do that are still intact, as far as I can tell.
One nuts and bolts question about the conservatorship. If the court were to reverse as to one parent or as to both parents, what would happen to the department's appointment as conservator? Would that be vacated, and would we tell the trial court or the Court of Appeals to reassess that in the first instance, or would we make some determination about that?
If the court upholds the conservatorship's still in place for the mother, and the department could seek a further termination.
Right, I guess I'm saying, like, I'm not saying this is going to happen, but if the court were to reverse as to, say, father and restore his rights as to the three younger children in the case, would the trial court then need to reassess whether conservatorship is warranted in the first instance? Or would you ask us to leave that in place?
So the court can terminate can reverse the termination grounds. Of course, we think there's no basis to do that, but and leave the conservatorship in place because the conservatorship is subject to a lower standard of proof. It's just a preponderance on whether there's grounds to keep the department as the conservator.
Any further questions? Thank you, Mr. Scanlon. Mr. Sharpe, you have 5 minutes.
In response to the last question, Justice, obviously we're asking for a reverse and render on the termination and the conservatorship. There is no evidence on those three younger children with regard to the mother or the father. And in fact, as Justice Lerman's pointed out, the department's position, or part of it was that the three younger children are the golden children that get whatever they want. And it's the older child, the stepchild, that suffers. So there's no basis for conservatorship of the department on those three younger children. And agreeing with Justice, it's asking about the constitutional provisions. Obviously, as the court is aware, it's been long-standing from both the U.S. Supreme Court and this Supreme Court that the parental rights are of a constitutional dimension.
What is your response to the evidence that the father was fleeing from police pursuit and found with methamphetamines in his pocket?
Well, my response is that's unfortunate that it had to happen while the case was still pending. I'm familiar, we've had an opinion come out that said the court can consider post-removal conduct in looking at the termination. I would echo what one of the justices pointed out, that this was after removal, the children were not there. It's one instance, So to be technical, under D, I believe it is, there has to be a course of conduct.
Well,
I
to
don't-
be caught with meth in your pocket doesn't mean that's the only time meth's been in that pocket,
Well,
right?
you can infer that,
Well, I
okay,
mean,
but that's not a
something that
fact.
a jury could
It
infer
could
from the
very well be
evidence.
that that's the first time I've ever had a bag of meth in my pocket. It is certainly possible. And I don't, it's outside the record and maybe not appropriate, but this is a guy whose family's been destroyed at this point in time. His kids have been removed, who God knows what's going on in that house with this going on. And did he have a moment of poor judgment? Obviously so. But in my humble opinion and in Petitioner's opinion, that one mistake certainly should not justify a termination when there were no allegations of abuse against his father whatsoever. I would like to demonstrate for the court, we do need to have some sort of line that determines when the state's interest in protecting children outweighs the parent's interest in having the right to raise them. That is the core question. And it is a difficult question. It reminds me of the obscenity question, where you're like, I can't tell you what it is, but I know it when I see it. And that might lend us to maybe letting the jury make the determination on that. But if we go the other route, if we say, okay, the state has an interest and we need to have a lines of demarcation on when this is, what are we going to have?
I wonder if on the question of excessive discipline, if it's almost a reverse jury rule, where if reasonable minds could disagree, then
they very well
the
could.
parent has to have the leeway to do it, or else it's ephemeral to claim that the parent has the right to discipline their children.
I mean, you have a situation, and I don't know if I'm addressing your question specifically, but you might have a strong-willed child that says, I'm not going to school. I ain't going. Okay, well, I know how my parents and probably how this court would handle that situation. Are we in a position now where we go, okay, we're going to set up an appointment with the school counselor and a therapeutic counselor and family counseling, and we're going to get to the bottom of why you think you don't have to go to school and why you can talk to your parents that way. Meanwhile, here's your ice cream. Is that the world we live in? Do we live in a world where the baby's born and the department says, here's appropriate discipline from birth to 3. Here's appropriate discipline from 3 to 6. Here's appropriate discipline from 6 to 10. Are we going to have state mandated guidelines on how you can discipline your child and not get in trouble with the state?
I think the suggestion is that the jury would decide that, just like they do in criminal cases. A jury who believes that some conduct should be rise to the level criminal conduct of being incarcerated or worse may not feel that way in Houston, Texas, but that's the way the juries work.
I understand that, and we are seeking to overturn a jury verdict, which is difficult, no question about that. But if you look at the record...
Just to be clear, my suggestion is that if any reasonable juror could have found it to be on the appropriate side of the line or within the parent's rights, then it is. And if it's not, that's not the case, then I just don't see how there's any right to raise your children as you see fit, because it's all just subject to later second guessing by the department or a jury.
That's right.
So you don't actually have the ability to
and we've got
make
no
your own
guarantee
decisions.
that the
You've got
jury... I'm sorry,
You
Justice.
just have do your best and hope that the government doesn't disagree with how you're raising your children.
Right, and again, we're leaving that up to jurors where we're not so sure that they're using the analysis that the court is using in looking at these things.
So did the jury instructions need to be different in these cases to appropriately guide a jury on questions like that?
Perhaps so, perhaps
I mean, I
so.
know that's not an issue in this case, but you've
No.
handled a lot of cases, so I'd like to hear
Yeah,
your
I
views
mean,
on that.
it would be nice if it was put out there that, yeah, just because you may disagree with how the discipline was done or how they're raising their children is not necessarily conclusive, particularly in termination cases. If we're talking about a regular custody case between mom and dad, that's a whole different thing. We're talking about a termination that you don't get to raise your children anymore because you made certain decisions, usually based on how you were raised. I'm not so sure that the jury under the current jury instructions is given that kind of strong indication on where the line should be drawn. And that's kind of what we're looking at, like we keep talking about, where is the line going to be drawn? Obviously, if a child is in the hospital with broken bones and a crushed skull, and you've all seen it, the most unimaginable abuse perpetrated on children. Obviously, they need to work their services, they need to do something, or they should get terminated. This case, we are suggesting is on the other side of the spectrum. We don't have drugs other than the meth arrest. The mother, there were no drugs, there was no alcohol, there was no allegations of some sort of locking him in the closet for 48 hours or any kind of sadistic abuse. Keep in mind, most of the allegations that are raised that are somewhat heinous are ones that were voiced by a child. I was put in timeout for days. You know, I think the jury needs
you, counsel.
to take some of that into account as well, you know.
Your time has expired. Thank you.
Thank you.
Mr. Sharpie. Thank you to all counsel. The case is submitted, and the court will take another brief recess.
All rise.